A very good morning to one and all.
Yeah,
I, Anjana R., Assistant Professor of Law, on behalf of CMR University, School of Legal Studies, warmly welcome you all to the second day of our 7-day faculty development program. We are delighted to have each one of you with us as we continue this academic journey, exploring diverse themes that shapes future legal education and practice. As we continue our academic journey into day 2 of this FDP, it is my honor to welcome our distinguished speaker, Professor Dr. P. Ishwara Bhat, former Vice-Chancellor of Karnataka State Law University and the West Bengal National University of Juridical Sciences, Kolkata. Professor Dr. Ishwara Bhat is a distinguished legal academician from Karnataka with over 4 decades of teaching and research experience in law. He began his teaching career in 1979, having previously taught at Karnataka University, Dharwad and MK Law College, Hassan, before joining Department of Studies in Law, University of Mysore. At Mysore University, he held several academic leadership positions, including Dean of the Faculty of the Law for terms and Acting Vice Chancellor. A gold medalist in constitutional law during his LLB, and a first rank holder and gold medalist in LLM from the University of Mysore. Professor Bhatt specialized in constitutional law. He earned his PhD in law with a thesis titled Interrelationship Among Fundamental Rights and also holds an MA in history. He was conferred with LLD by the National Law School of India University, Bangalore for his thesis on non-profit law. His research career is marked by numerous honors and international experiences. He received the Shastri Indo-Canadian Research Award in 1992, conducting a comparative study of language rights in Canada and India in Canadian universities. He has led funded research projects on multiculturalism in Indian constitutional law, international humanitarian law, and space law. As a visiting professor, he has taught at Queen's University, Kingston, Canada in 2009 and was a Fulbright Fellow at Columbus Law School, Catholic University of America, Washington in the year 2010. He also participated in the American Civilization course as a Salzburg Fellow in 1997. His areas of academic interest include administrative law, social change, water law, research methodology, world trade law, intellectual property rights, and non-profit organization law. He has contributed to drafting legislative bills and university statutes, adding a practical legislative dimension to his academic and research accomplishments. Sir, we are delighted to have you with us today here. Welcome, sir.
thank you. Faculty Development Program has this schedule that today the topic given is importance of research in teaching. This topic involves discussion about the way in which or extent to which research is applied for the purpose of teaching. Both are related to knowledge. Research is relating to generation of knowledge through systematic study of any specific question or specific problem, culling out facts, and arriving at appropriate conclusion, appropriate resolution of the problem. There ought to be use of specialized tools for that purpose. This is how research is conducted. Teaching is dissemination of knowledge, whether it is in a classroom or in a non-formal manner, informal manner. Whenever a dissemination of knowledge is done, we say that there is a teaching. How exactly teaching makes use of research, and what is the growing importance of research in a legal education? About these issues, I would like to share my thoughts. In fact, the relation between research and teaching is mutual, and uh, of course, they benefit each other. They are mutually supplementary because research enables creation of new knowledge, access to all the exhaustive information, and systematic analysis of both facts and law, and uh, some specific dimension of legal development. There is a direction of legal development, and what are the things involved in a uh, legal development. About this also, it throws light. For the purpose of teaching, a researcher will be exhaustively studying the subject, because preparation for teaching involves a thorough reading of the relevant area. There is a need to exhaustively know the law or know the subject on the basis of which teaching is to be done. That is how research is something that benefits dissemination of knowledge. For the purpose of that day's teaching, a teacher will be involving in a systematic preparation. Mere reading is not sufficient, because at the level of higher education, when teaching is to be conducted, especially when it is relating to course like law, a professional course, it is essential that the researcher should make a thorough and exhaustive study and analyze various issues, because it is not a mere narration or a mere say communication of knowledge, but how various problems that are involved in that subject are to be examined from the perspective of providing appropriate solution, so that ultimately application of law will result in promotion of justice. Because law has that primary purpose of promoting justice, ensuring social transformation, welfare, security, and all such things which are expected from the field of law. That's why the teacher should know the social purpose behind that law, social reason behind the law, and uh, communicate to his students all those things which are relating to the social background of that law, the analysis of that law, interpretation, how the judiciary has examined, and what are the prime uh, matters which are involved, and how exactly the trend of development is towards better protection of rights, or say enforcement of human rights, etc., or implementation of the constitutional goals and objectives. See, in the course of reading for the purpose of teaching, a researcher will be coming across various issues, various problematic issues. Further, various loopholes in the law, or loopholes in the application of law, or inefficiency in implementation, or some of the gaps in the field of law will also be realized by the researcher and the teacher at that juncture. And at the time of teaching, he may recollect such issues, and he may present his thoughts, his ideas, in addition to communicating the core content of that law. That this law teaching is not a merely mechanical presentation of the uh, legal developments, but critical legal thinking is required, so that the participants in the classroom will be responding to such a social issues, such a legal problems. Because about uh, knowledge of law, actually the students may get from other sources, or they might have come with adequate preparation, or uh, there is a access to multitude method of getting information through Google or through various other resources. It is possible to get information. But how a student can be motivated and how he can be sensitized to various social issues or various problematic factors about this, the teacher has to take into consideration, because ultimately what is going to be remembered by the student, or what is going to be received by the student, is some of the problematic areas or some of the issues that are involved, uh, I mean controversies that are involved in understanding the subject. See, when he makes such presentations in the classroom, actually the uh, the uh, conflicts that he presents, or the disputes that he points out, or the uh, the sparks of thoughts, sparks of new ideas that he generates in the course of discussion, will be inviting some person or inviting the teacher himself to further investigate and conduct research. That is why between teaching and research, there is a mutual supplementary relation, mutual relation of reinforcement can be found. Then, what are the growing reasons for uh, importance of research in teaching? About this, let me point out. There has been tremendous growth of legal education uh, because of its growing importance and uh, entry into various spheres. And we find that legal education is becoming a very popular and even a substitute for some of the technical courses as well. Fast changing law is to be properly understood by the teacher, and it should be presented to the students. New interpretations might have arisen, new developments might have taken place, and there might be newly emerging social relevance, and some controversial issues might also be there. It might be relating to some of the problems relating to women, or sexual minorities, or children, or various other things, or about non-implementation of law, or some of the challenges that are posed in the technological world about the efficacy of law. Further, social justice issues affecting the tribals, or affecting the poor people, or affecting women, Dalits, and other sections of the society, vulnerable sections of the society might be involved. And the teacher has a responsibility as a social leader of a knowledge system to engage the attention of attract the attention of the students relating to these problems. Thus, the dynamism of legal development ought to be properly highlighted. And when a phenomenal change has taken place in the field of legal education, the researcher has to apply high quality legal research, and he has to enlighten to the students about the up to date information and the trends of development. There are various ways in which uh, legal education have become highly sophisticated and modernized. Moot courts, legal aid clinics, then legal literacy programs, then judgment writing, internships, then writing research articles, and engaging in research projects, handling research projects, or uh, drafting of new law. All these types of activities are uh, conducted in law schools. And the these are sometimes in addition to the regular teaching. There's uh, a co-curricular uh, aspects of legal education. It supplements legal education, and while organizing these types of activities, the teacher has to take the support of research so that these activities will become successful. For example, moot court competitions uh, invite uh, so many research skills. Actually, the students have to sharpen their research skill. They have to engage in uh, research activities so that new arguments can be put forward. As a teacher, the uh, the teacher has to set the moot court problem, and for that purpose, research is to be conducted. Then, for training the students in moot court activities, again, research component is there. Then, research works from the side of teachers is very much required to equip himself with the latest developments and latest demands of the legal education. For example, bar council might be prescribing new subjects or suggesting new approaches or inviting the need for an interdisciplinary approach. Similarly, there might be some new issues. Liberalization, privatization, globalization might have introduced some of the newly challenging subjects. Then, demands for social justice might be requiring that the the students should be highlighted about the latest developments. Then, 5 years course requires a interdisciplinary approach, and of course, all law schools are engaging in these activities, and there are competitions among the law schools, whether it is a national law school or uh, law schools of private universities or deemed to be universities or private law colleges or say affiliated institutions or say state universities or traditional universities. In all these centers of legal education, when there is a demand for excellent legal education, it is essential that the requirement is to be satisfied through excellent legal research. That is why research becomes essential at the individual level, at the institutional level. See, long back, uh, legal education was confined to training the students for, say, uh, entry into the bar, entry into the bar. That was the, or enabling them to enter into the bar. That was the only purpose that was served by legal education. Uh, See, during a colonial period, that was sufficient, or that was the limited objective of a legal education. But it was uh, taught uh, at the dawn of independence by certain specialized commissions on education. Yes, Radhakrishnan Committee on Education pointed out that unfortunately, legal education is a field where legal research is very, very inadequately done. It is very much essential that there should be sound legal scholarship uh, on the part of law graduates as well as law teachers. But this is not taking place. It is essential that law colleges should be centers of legal research. High level research is to be conducted. For this purpose, uh, a good law library and various other uh, requirements. There's a training the teachers in the field of legal research all these become very much essential according to this committee. Then, uh, in some of the s- leading centers of legal education, there's a Banaras Hindu University and Delhi University Law School. Various steps were taken to uh, to level up the extent of research so that the teachers will be well equipped in a uh, legal knowledge as well as uh, resolving various issues and providing excellent legal education through their research activity. Justice Krishna here had pointed out during 1970s that the contribution of legal education or legal academia to uh, the socially relevant legal research uh, is very much wanting. There is a need to develop socio-legal research, especially in matters relating to administration of a criminal justice system. There is a need for such a research, and research is not adequately contributing. Then, Law Commission in the 1950s had pointed out that there ought to be adequate development of research faculty. The law teachers should have very good expertise in the field of subject. That's why sound research performance from the side of teachers is very much essential, and this ought to be popularized. That's it is not a mere recommendatory thing, but it ought to be made mandatory that the law teachers should have adequate expertise in the subject. Then in the 1980s, there was a big change in a legal education system. National Law School system was introduced in 1988. It was followed by establishing of a number of uh, national law schools in different uh, states, and a lot of emphasis was given to research, and teaching could be ventured only on the basis of thorough reading and thorough research. Without research, it was not possible to handle any of the classes in such a uh, law schools because of the uh, high demand from the side of students. There's a they were uh, uh, asking questions. They're engaging in a number of discussions and involving in a uh, say first-hand research by uh, using various specialized tools of research. That's why uh, there was a need to develop the research competence, and in a number of institutions, new research programs were launched or they were made strong, and national law schools also uh, launched a number of journals. That's the requirement that there ought to be better research output from the side of teachers was very much emphasized. Justice A.M. Ahmad committee pointed out that law teacher has a specialized role in producing socially responsible legal professionals. Socially responsible legal professions. How it can be done? See, uh, the competence to conduct social research, competence to uh, use law to promote the cause of social justice, and uh, thorough knowledge relating to the very structure of a legal system, and the way in which that legal system is actually functioning. All these things are very much essential according to Justice A.M. Ahmadi. Justice A.S. Anand also pointed out that law reflects social ethos, and being a social science, it is only to be understood through thorough research. Then problem solving skill ought to be considered as a very important aspect of legal education, and legal research is the method of providing or developing that kind of uh, problem solving skill, according to scholars like IP Massey. Then new education policy has required that there ought to be focus on Indian knowledge system, Indian culture, under whose background the whole legal system got developed. Then it emphasized that there ought to be bilingualism. Thirdly, the technical aspects of a law, or the technical world to which a law is to be applied. About all these things, there ought to be thorough information. There's a law ought to be made technically sound, and the lawyers should have first-hand knowledge of the technology through which a law can be put into application, whether it is a cyber law, or IPR law, or any other field of technology. A law student should have adequate awareness. In order that a law student should have awareness, the teacher should have awareness, because today it is not possible to teach various subjects having a technical dimension without technical knowledge. Then there ought to be adequate focus on social justice, how legal education can promote cause of social justice. See, these are some of the proposals made in a national education policy. Professor N.R. Madhav Menon was a doyen of legal education. He was responsible for introducing these elements in a new educational policy. Of course, his contribution was great insofar as the evolution of a national law school system is concerned, because he was the founder vice-chancellor of two prominent national law universities, and he made a bigger contribution. And he was emphasizing about research. Uh, See how the teachers should engage in meaningful research, not only for the purpose of promoting their own career, but even for other purposes. Hello, am I?
Yeah,
Uh,
audible, audible.
yes, yes, yes. Yes, these are the growing reasons for use of research in the task of teaching, especially law teaching. Now, how research helps teaching, uh, about this we can discuss. Firstly, research enables the teacher to improve his teaching. How to teach law? About that, research uh, from his side will help him to improve the quality of teaching. There are several methods of teaching. There is a lecture method, seminar method, case method, and moot court method, and some other methods or combination of methods can also be employed. See, in order to know the importance of each of those methods, the teacher should have first-hand knowledge of the way in which that teaching method is to be handled. For example, case method. See, uh, imparting knowledge relating to a particular uh, law just on the basis of a discussion of a case law, that is one method. See, in American universities as well as in Delhi University, this system became very popular, and it is only by discussion of cases that ultimately the syllabus will be covered, or the major area of the subject will be properly uh, covered, or that knowledge will be disseminated. And for this purpose, a thorough research is required. Suppose it is something relating to basic structure theory, from a Keshavananda case to NJAC case or other cases. Whole of the legal development is to be examined, it is to be studied, and some of the latest, even post NJAC judgments, like yes, judgments relating to reservation. There's a Maratha reservation, or say reservation for EWS. All these are to be studied. Each judgment is a minimum 500 pages, and thoroughly discussing those cases requires the teacher to uh, meticulously involve in the study of that case, or that development, because he cannot just confine himself to the doctrine. How exactly various other scholars looked into that issue, or how exactly other writers have come up with certain interpretations relating to those judgments, or evaluation of those judgments. See, there's a use of these teaching skills uh, is to be done keeping in mind uh, how the teachers, how the uh, requirement of students will also be properly satisfied. See, legal education expects that the products of a legal education, there is a law graduates, should equip in themselves uh, the skill. There's a oral skill of debating, or say writing, or say drafting statutes, or such other skills. See, the choice of this teaching skill or teaching method should satisfy that requirement, because ultimately, through legal education, you are preparing the lawyers, preparing the future lawyers, and such a lawyers should have all such abilities. See, next question is uh, what to teach. See, research can help teaching uh, by uh, by uh, providing all such inputs which are essential for legal education. See, uh, what to teach. When the teacher asks that question to himself, he will find that it is essential to teach the social reason behind the law, historical genesis of that law, the social purpose of that law, and how it fulfills that social purpose, or how it does not fulfill the social purpose. What are the difficulties that are involved in in the application of that law? About all those things, it is essential to know. That's why what to teach is actually taking the researcher come teacher to the policies of that law, then for uh, uh, communicating the legal knowledge, actually interdisciplinary approach is required. See how exactly particular law has certain difficulties. This can be properly examined by looking to the uh, disciplines which are related to law, or which becomes which become relevant in the application of the uh, legal principle. For example, Donog versus Stevenson is a judgment that can be analyzed by taking into consideration the historical background of it, the uh, political factors that are involved in a evolution of manufacturer's liability, then the economic change, the change in the economic philosophy from a laissez-faire state to welfare state, from a caveat venditor to uh, caveat yes, caveat emptor, from a caveat emptor to caveat venditor. There's a manufacturer's liability, or the vendor's liability. From that perspective, one has to examine. Then psychologically, this law has infused self-confidence in the minds of the consumers. Consumers were vulnerable, and they were prone to suffer various uh, difficulties. But this case inaugurated a new era. So, in teaching the subject, there's a manufacturer liability, or the principle laid down in Dono versus Stevenson. The teacher has to examine these aspects, because uh, a full knowledge, or a comprehensive knowledge of the subject can be obtained only by disclosing, or yes, by uh, imparting all this information. Then what to teach? See, preparation for a research project from the side of a student will have to be supervised or guided by the teacher. Teacher assigns the research topics. Of course, he has to assign some challenging topics. Then he has to supervise. He has to suggest the possible source of information, and ultimately he has to evaluate. In the course of doing all these things, the teacher has to invariably involve in a research activity. Then uh, the uh, teacher, while teaching some of the higher programs like a LLM program, or a MPhil program, or a PhD program, PhD coursework, etc., has to engage in a research activity, because it is only a teacher who has a uh, active involvement in research can fulfill the responsibility of a good researcher, a good teacher in a research methodology. A good teacher in a research methodology should be able to attract the attention of students only on the basis of such a uh, activist research from his side. Then there arises the question, why to teach? See, we teach law students with a hope that we are shaping the future lawyers with all such abilities to compete with other uh, fellow professionals. See, that's how the student has a social sensitivity, how he has a human rights uh, approach, or how he is an activist in handling the human rights issues, and how he can make use of his knowledge and skill. See, all these types of preparations that we make for our students should be adequately supported by research from the side of teachers. If teachers are poor researchers or poor trainers, then students will not be getting good instruction about the way in which research is to be conducted, the way in which problems are to be resolved, or the way in which the social issue is to be handled. That is why uh, teacher as a leader of the knowledge system has to provide all such a lead, all such information. Then uh, teaching whom? See, uh, if it is a law college or a mere law school, one will be teaching undergraduates. But one will be teaching LLM students. One will be teaching say PhD candidates in the course of uh, this PhD coursework, or he may be teaching outside the law school. There's a in the context of spreading legal awareness in a legal aid camps or legal awareness camps. When the teacher engages uh, the audience about the uh, legal principles, legal procedure, and the way in which legal system is operating, actually his audience will be different. Similarly, there might be participants in some of the training programs, and for them, when he conducts his teaching assignment, he has to thoroughly prepare himself. There's a he will not be confining only to law graduates. Even for law graduates, it is essential that the teaching should be associated with adequate adequate uh, research work, because some of the latest issues maybe relating to same-sex marriage, or relating to say uh, the issues of federalism, or president's or governor's power of giving consent, or not give, or his discretion not to give consent, parliamentary democracy. Then so many issues are there, so many controversial issues. About this, the teacher has to enlighten the students only with the uh, thorough research. Otherwise, he'll not be fulfilling the responsibility of a teacher. Lends his service as a teacher outside the classroom, say in seminars or workshops, or in a moot courts, or legal training, or training uh, of students for a judicial service examination or a competitive examinations, or when he guides the students in legal aid clinics, in all these spheres outside the classroom, when he engages uh, the students for these types of activities, actually the teacher can be a successful teacher